So a seaman has a variety of rights when they get injured on the job, and they have a variety of potential claims that might be available to them. First is a claim for negligence against their employer under the Jones Act. What's unique about this claim for seamen is that it's one of the only industries in the country where an injured worker can file a lawsuit and have a negligence claim against their employer. Seamen have always been protected by the courts, and the Jones Act is a law that is designed to give them rights that other workers do not have. They can also make a claim for what's called the unseaworthiness of a vessel. And that is if something is wrong with the vessel that they were working on and that defect caused their injury, they can, again, sue the ship owner to recover their damages. Finally, a seaman has a right to what's called maintenance and cure. And this is a remedy that exists only for seamen. And again, it's something that the employer is obligated to give them regardless of fault. So whether or not the employer did anything wrong doesn't matter. If a seaman gets hurt while on the job, they are entitled to maintenance and cure. Maintenance is a daily payment from the employer that's designed to cover the seaman's living expenses. Cure is the obligation of the employer to pay for all medical treatment that is related to the injury that occurred aboard the vessel. Well, really, any injury that they suffer while working offshore or aboard a vessel gives them the potential right to make a claim. Again, regardless of whether anyone did anything wrong to cause the injury, a seaman can get their maintenance and cure. With respect to the kinds of incidents and injuries we typically see that might give rise to a negligence or an unseaworthiness claim, it can really be a whole variety of things. They could be working in some sort of unsafe condition, whether there's some slippery substance on the deck of a vessel. They could be forced to work in unsafe weather conditions, in a storm. There could be a piece of equipment on the vessel that's not working and causes the injury. They could have to lift something that's too heavy for them to be lifting on their own. Really, any injury has the potential to lead to a claim against the employer or the ship owner for either negligence or unseaworthiness. We've seen a whole gamut of different kinds of injuries. Some of the most common injuries we see are back injuries, which are often caused by some sort of heavy lifting or strain that's put upon the seaman when he's asked to do an unsafe task. We've seen traumatic brain injuries. There's heavy equipment out on a vessel or offshore, and if a seaman or a worker gets struck in the head with something, we've dealt with a lot of traumatic brain injuries, and those obviously can be very significant and affect an individual for the rest of their life. We've seen torn knees, torn shoulders, broken limbs, and we've certainly had a lot of wrongful death cases. Because when something goes wrong out at sea, the effects can be substantial, ranging from minor injuries all the way to death. It's an area of the law that is constantly evolving, and there's major decisions on what may qualify someone as a seaman that come out on a regular basis, and frankly, the courts often are confused by that issue. There are a few different factors we look at. One is, does the seaman contribute to the mission of the vessel that they're working aboard? And that's typically a test that's easily met. Whether someone's a cook or an engineer or the captain of the vessel, if they're working on a boat, they are usually contributing to the mission of the vessel. The harder question is, do they have a substantial connection to the vessel? And to answer that question, we need to look at how much time an individual may be working on a particular vessel. What percentage of their employment is spent aboard that vessel? Do they get assigned to different vessels that may be owned by different ship owners? Those are all factors that we need to look at. And frankly, it's a complicated issue, and one that you really need an experienced maritime attorney to be able to answer those questions for you.